Hello, my name is Amritan Sharora with ThePrint, and here we are at the Jaipur Literature Festival, where I am in conversation with former Justice S. Muralidhar, who served as the Chief Justice of the Orissa High Court, 32nd Chief Justice of the Orissa High Court, sir. We're going to get into questions right away. My first question to you is, in your illustrious legal career, you have appeared for the Council for the Election Commission of India as well as the National Human Rights Commission. How would you sum up the Supreme Court's seemingly lackadaisical approach to its ruling on the validity of electoral bonds, since we know that the verdict was reserved, and how would you view this?
Yeah, I see the courts as a democratic space where people should be permitted to express their views. Their views may be agreed with or disagreed with, but their space must be given to express their views. Measures adopted by the government, which has long-standing ramification on the way electoral politics is played out in the country, is an issue that deserves top priority. So I think this is a case that really deserves top priority as far as the Supreme Court is concerned.
So my second question to you is, during your tenure as a judge of the Delhi High Court, there were two particular incidents that were widely reported in the media. One where you pulled up Delhi police officials for delay in registering FIRs in connection with the communal violence that broke out in the national capital in the first half of 2020. And I quote, you said that this city has seen enough violence and the police must not let a repeat of 1984 happen. But we've seen over the past few months that there has been delay on the part of the police in filing charge sheets. Many of the charges that they have pressed against the accused have not stood the test of judicial scrutiny before the courts. The needle has hardly moved in the case of hate speeches delivered by certain leaders, which are very much in the public domain. There's no doubt that they did deliver those speeches. Do you think this approach of the Delhi police in handling of the 2020 Delhi riots cases dilutes its credibility?
See, the whole justice system is to hold power to account, right? And it should let people speak truth to power. This is one of the fundamental functions of a court. And what I was doing, just to correct you just a bit, I was not asking them why had they not registered FIRs. I was asking them why had they not taken a decision after viewing the videos on whether you need to register an FIR or not. I mean, they could have come to the court on the next day and said, no, after viewing the videos, we don't think an FIR should be registered, which should have led to another set of questions to be asked. But even that initial, viewing the videos and making up your mind whether an FIR needs to be registered or not, that is such an essential function of the police. And they were not prepared to do that in that, point in time. And it is also signaling that, this acting with, you've heard the word impunity, where you're unwilling to prosecute people, then you have the problem of impunity. You have another problem of immunity, where the person perpetrating it happens to be a state actor. Lets the police itself, ransacks a place and commits acts of violence. In order to prosecute people in the police, you need sanction from the government. And the government is unwilling to give you sanction. So there is an immunity attached to acts of police force because you cannot prosecute them without sanction. So you have the interplay of both impunity and immunity. And this was the classic situation which we are seeing now play out, that we are not able to prosecute effectively people who actually perpetuated that violence. And the cases against members of certain communities have now found to be, not made out at all. So it does speak to the lack of neutrality in the approach of the police in prosecuting these cases.
So my next question is, as Chief Justice of the Orissa High Court, you said once that laws in India are structured to discriminate against the poor. it's evident that an overhaul in the Indian judicial system is long overdue. But in your opinion, can the legislature be trusted to rise above partisan interests when considering the overhaul of overarching laws?
Yeah, see, again, it depends on what happens in a legislature. When you have one party dominate the legislature by sheer numbers, getting that party to do something which is contrary to its own interests is difficult. Like electoral reforms, for instance. This whole thing of a candidate having to disclose criminal antecedents. If you had left it to the parliament to do it on its own, it never would have done, because all of them sitting there see it in their interest not to have such a law. So the push had to come from the court. Likewise, decriminalizing activities of the poor is a push that has come from the court. I'm talking of the anti-beggary laws, which the Delhi High Court struck down, Justice Geeta Mittal's bench. She did the same thing in Jammu and Kashmir as well. So now in Delhi, they'll have to treat this issue differently, because it's not a crime to be begging, because you're compelled to be on the streets seeking alms. So likewise, there are many such activities of the poor which are now criminalized because of a colonial hangover. And that we have not paid attention to. These people are unnecessarily dragged into the criminal justice system, from which there is no easy escape. So that is what I meant by the laws itself being oppressive to the poor.
So, what is your reading of the 3 new criminal laws? If you could give us a brief understanding of how do you think it will impact the criminal system, like the criminal system in India.
There are some basic rules about laws. First, if you're going to change a law, it should be a change for the better, right? Not a change for the worse. Second, the subject matter of the law should be the citizen and not the state. It should be citizen-centric law. Third, the law should be easy to be understood, and it should be easy to be communicated. And it should actually remedy the problem that was pointed out over all the years of various provisions of the law. And it should lend clarity, right? It should not add to confusion. So if you test these 3 laws against each of these parameters, you'll find them falling far short, right? So this is a very basic exercise. In England, you have a movement of simplifying the language of the law. They pass on a statute in the form of a bill to 5 laypersons and tell them, can you understand these provisions? If none of them is able to understand, only 2 of them out of 5 is able to understand, they rework at the wording of the law. I don't see that kind of an exercise having been undertaken at all here. This is not based on empirical studies. It seems to be a hurried exercise. I don't think there was enough consultation, particularly consultation among practitioners of the law. 2 important actors here, the police and the criminal bar, they need to be consulted extensively. If there is delay in notifying these laws, it's because of the lack of preparedness, even from the police force, for this kind of a huge change. I'm so used to registering, somebody comes, cheating ho gaya ji. The constable says 420. Because it's wired into a system, right? Somebody says, I have been sold property, but the sale deed is forged. The man immediately says 420, read it 468, read it 471. Now you go and change these provisions. 420 is no longer 420, it's some other number. Now the constable gets it wrong, then the court will get it wrong. Then you'll be in for a wrong offense. What is cognizable is now, a different section. What was non-cognizable is a different section. You go by the older numbers. What was non-cognizable, you treat it as cognizable, and you start arresting people. So this tinkering with criminal laws has to be done very, very consciously being conscious of the enormous complexities in the way our system works. And these criminal laws operate at the lowest village level. It's not only some courts where very well-informed people are dealing with the laws. IPC, CRPC and Evidence Act all operate at that level of the village. And that village, that taluk level, district level, I don't think they have understood what the ramifications of these changes are.
I have just some few questions, last few questions before we wrap up. Your favorite musician or singer?
Kumar Gandharv.
Okay, 2 or 3 books that you would recommend to young Indians who would want to better understand the legal system in India and around the world.
Crisis of the Indian Legal System by Professor Upendra Bakshi. I think it's not been reprinted. I would urge whichever is the publisher to reprint it. It's a timeless book, must read. A Team of Rivals. This is Professor Keening of the United States of America, who explains the life of Abraham Lincoln and his days as a lawyer. The Man Before the Mahatma by Charles DeSalvo, which will explain to you the struggles of Mahatma Gandhi in South Africa as a young lawyer. And it's very inspiring to read about his struggles and how he overcame them. So these three books I would definitely recommend.
So my final question is, how do you unwind after a long day at work?
Music, definitely, but more important, laughter with family and friends.
Thank you so much for taking out the time to speak with us, sir.